the difference is one is legal, the other is not.
Okay, and the reason I ask this is because most people would refer to it as a constitutional convention, and I wanted that definition, I wanted that explanation out there. This is, in fact, what we're looking at here is an Article 5 convention.
Correct, and that is specifically and expressly to offer amendments, propose amendments, not get them into the Constitution, but to consider and propose amendments to our present Constitution. Can't rewrite the Constitution. It can't take things out of the Constitution except by amendment that replaces language like the rest of the amendments do. That is all it can do, just like the same thing as Congress. They are exactly the same power. So if you understand how Congress proposes an amendment, you understand how a convention proposes. They're identical.
That's perfect, and that's what we needed. Thank you, sir. The next question is, okay, what's the proper procedure for we the people to call for an Article 5 convention, and what is the responsibility of Congress and the ramifications if Congress does not comply?
First of all, the Article 5 specifies out that the two-thirds of the several state legislatures must apply for a convention call. This is where a lot of people get mixed up. They assume that this is for the states proposing an amendment. States cannot propose amendments. Now, in the 1787 convention, again, without going into a lot of detail, they discussed doing that twice. They rejected it. They voted it. They were not going to do it. Ultimately, what came out was when the states said they wanted a convention, Congress had to call. So the answer is that two-thirds of state legislatures have to send in applications to Congress and say, hey, we want a convention to propose amendments. Now, they, in these applications, of course, can submit their ideas to the convention. People can submit their ideas to the convention, but that kind of goes ahead of what your question is asking. The bottom line is they send in the applications when there is, right now, since there's 50 states, when there's 34 of them, the Congress then is supposed to obey the Constitution, call the convention. The convention is held. It debates over the proposed amendments from the states, from the people, from their own ideas, whatever. They propose it with two-thirds of the state delegations. It then goes to Congress, who then picks a form of ratification, either state conventions or state legislatures. Three-quarters of them, either way, have to approve it. If they do it, then you get your amendment. It is a very complicated, difficult process. It was intended by the founders to be that, yet it does allow for changes, and it is, without question, the highest standard of amendment change in any constitution in the world. There's nothing that's more difficult than amending the United States Constitution, which again knocks down the runaway convention because the JBS comes out and says they expect that a convention could do that instantly, and there's no way. It just is not doable.
No, there's too much to go through to do it instantly, and too much review and discussion, and it's more than just going in and saying, okay, this is what we're going to do, and it's done. Right.
But here's the thing that a lot of people don't understand about amendments. They say, well, it's so slow, we could get it done. The Congressional Research Service has checked the average time it takes to ratify an amendment. It's faster on average than our election cycle. So in other words, it is deliberate, but it's real quick. 1 year, 8 months from time it is proposed until it's ratified on average. So when somebody says they want something done quick and they want it done permanent, that's what they're talking about. That's how fast legally it on average moves. Now, some are a lot longer. But the point is, it is long enough, even in that time period, for people to deliberate. And when you're talking the large number of states and stuff that you're discussing, you don't have any worries. I mean, it's going to be argued. It's going to be debate. It's going to be fought over. It's not something that just walks through. Check the history of any of the proposed amendments. Even the original 10 took like a year to get ratified, and they were asked for by the states themselves.
So, again, what are the ramifications if we call for a convention and we've got our 34 states and Congress does not comply?
Then, if nothing is done, you're establishing that Congress has the right to veto the Constitution. You'd have the right of the Congress to ignore any provision of the Constitution. Once you've accepted the principle that the Congress can ignore the Constitution, they can ignore the Constitution. So your legal ramifications is that essentially the document would cease to exist as an effectively managing. That's why holding the convention is so important. It doesn't matter even if they don't propose anything. To keep the Constitution viable, it has to be obeyed. The Constitution says if the states apply, there's a convention. The states have applied.